Hello, welcome to our Federal Employee Unions Compatible with National Security Competing Perspectives. I'm Merrick Masters, and I'm Professor of Business Emeritus, commentator, and podcaster. You can find me at my email address and also at my YouTube channel. President Trump has taken the most far-reaching actions to reverse labor rights in the federal service, effectively removing most represented employees from the Federal Service Labor Management Relations Statute. The issue is whether or not union representation, and that includes recognition, bargaining rights, and grievance administration, are consistent with the effective management of agencies with a national security mission. A subsumed but unanswered question is what defines a national security mission sufficient to waive the protections of the statute. Federal employee unions, it's important to realize, have comparatively limited powers versus their counterparts under the National Labor Relations Act. They do not have the right to strike. They do not have the right to bargain over compensation, including wages and benefits, and they are confronted with a very strong management rights clause, which is defined by statute itself. And these unions have never had an opportunity to negotiate an agency shop which would compel compulsory dues of represented employees. There is one perspective that is held by some, particularly those on the conservative side of the aisle, about the managerial and operational ineffectiveness and inefficiency of having union representation in the federal service. The basic thesis is that in this context, a national security mission requires maximum managerial flexibility and efficiency. Unions restrain and delay management decision-making and agility. They lower productivity through rigid contractual requirements, and through cumbersome work rules, unions diminish effective organizational performance. This is really one of the arguments proffered by Freeman and Medoff in their seminal book on What Do Unions Do, about the two faces of unionism. This is the anti-efficiency monopoly view of unions that they present. And as a counter to that, they also present the union voice mechanism, in which they say unions offer employees a voice that shares important information with management that can be used to improve operations. Through having such a voice, working conditions will improve and thereby increase employees' commitment to the organization and reduce turnover. And unions encourage employers to provide more training and better equipment, and thus increase the performance of the organization overall. These are the competing perspectives which define the debate today. The statute itself, the Federal Service Labor Management Relations Statute of 1978, provides that the president may issue an order excluding agency or subdivision thereof from coverage of the statute if it has as a primary function intelligence, counterintelligence, investigative, or national security work. The national security basis for excluding such agencies was addressed partially in the statute itself, which exempted the Federal Bureau of Investigation, the Central Intelligence Agency, and the National Security Agency from the protections of the statute, the labor right protections for employees in those agencies. After 9/11, there were 3 statutes passed which gave the executive branch the authority to define new personnel systems to meet national security needs, and these included the newly formed Transportation Security Administration, which oversaw the federalized airport screeners, the Department of Homeland Security, and the Department of Defense, through an Authorization Act of 2023, which authorized that it create a modified labor relations system to accommodate the needs of national security. Executive Order 13480, issued by President Bush, George W. Bush, on November 6, 2008, said that there are several sub-agencies of the Department of Energy, the Department of Homeland Security, the Department of Justice, the Department of Transportation, and the Department of Treasury, which are excluded from protection of the Act, but these agencies were relatively limited in scope. President Trump, on March the 27th, 2025, issued a new executive order 14251 on exclusions from Federal Labor Management Relations Program, and these excluded the following departments more or less from the protection of the Federal Service Labor Management Relations Statute: Energy, State, Justice, Treasury, Veterans Affairs. There were also large parts of the Department of Defense which were excluded, and therefore these agencies had a lot of already represented employees which are no longer entitled to be represented by unions. More than 1 million union represented employees were removed from the Federal Service Labor Management Relations Statute, losing their rights of recognition and collective bargaining. Shortly prior to that, the Secretary of Department of Homeland Security used authority under the Homeland Security Act of 2022 to reverse the collective bargaining rights of airport screeners. A determination was made that this was basically inconsistent with the national security function of the agency and its employees, and therefore they should not have the right to bargain collectively or be recognized for such purpose. A broader question that this raises is one that is unaddressed but is really prevalent in the current debate over the national security exclusions, is whether union representation in the federal service is consistent with the public interest. President Trump has defined national security mission so broadly that it waives a large part of the federal sector from the protection of the statute, and therefore raises the question of whether or not there are any conditions in which union representation might be reconcilable with the public interest. This is a long-standing question of major import in federal service. It involves issues of sovereignty and the role of labor unions as institutions. There is currently legislation introduced in the Congress to ban union representation in the federal service. It's sponsored by Senators Blackburn and Lee. Legislation is called Federal Workforce Freedom Act, and it would repeal the statutory framework, the Federal Service Labor Management Relations Statute, that currently governs federal labor relations, and prohibit federal employees from being allowed to organize, join, or participate in labor unions for the purposes of collective bargaining or representation. Where things stand now is that President Trump, by executive order, has decided to define a large sphere of the federal sector as operating under a national security mission and invoke that power to exclude these agencies and their employees from the protections of labor rights under the Federal Service Labor Management Relations Statute, and therefore they lose their status of union representation and also the right to bargain collectively to set terms and conditions of employment. This is the most sweeping act to roll back federal employee union rights really in the history of government, certainly contemporary government, and it essentially rolls back the protections that were originally granted under executive order by President Kennedy. The Congress thought and the unions thought that when it enacted the Federal Service Labor Management Relations Statute, that the statute itself would protect employees in this regard, and the national security exclusion power would be used to only a very limited extent, but has been used much more broadly here and therefore raises important constitutional questions about the scope of executive authority, the interpretation of the statute, and actually the inherent wisdom of having any union representation in the federal service. I hope you've enjoyed this presentation. Stay tuned for more. I'm Merrick Masters. Here's a little bit more about me, and I'll be covering this issue in great detail in the weeks and months ahead. Thank you.